Driving charges can arise in circumstances where a person is caught driving on a highway or a road, in circumstances where they're either disqualified or suspended from doing so. There can be a difference in the seriousness when a person is caught driving disqualified after having been disqualified by a court, as opposed to being caught driving suspended from Vicroads because of demerit points. And that's because when you're caught disqualified after a court has disqualified you, you're disobeying a court order. The police need to prove that you were driving on a highway or a road and that you were either disqualified or suspended. The defences for driving disqualified or driving suspended are either a factual dispute as to whether or not you were in fact disqualified or suspended, but more commonly it's whether or not you had an honest and reasonable belief that you were able to drive. I had a client who was charged with driving whilst disqualified, and he was disqualified by the court for 8 years in 2005 following a drink driving offence. He was caught driving a work vehicle, and his instructions were that he normally had employed other people to drive the car for him, but on this occasion he was investigating a strange noise that the vehicle was making and had only driven it a short distance before he was intercepted by the police. He had an extensive driving history which included driving whilst disqualified and also drink driving, but this was the first charge of driving whilst disqualified that he'd had since that really extensive disqualification period. Since 2005, when he lost his licence for that extended period of time, he'd made some significant changes in his life. He'd been working as a lifeguard for 20 years and he'd stopped working in that field. He'd started working with special needs children, he'd become a father and had addressed a long-standing alcohol problem. I was able to persuade the magistrate not to impose an immediate jail term. He received a 2-month term of imprisonment that was wholly suspended for 6 months and was able to persuade the magistrate not to interfere with his licence. There is, however, a maximum penalty of 2 years for the charge of driving disqualified or suspended. The decision of whether to plead guilty or not guilty is one that has important implications and should only be made after discussions with a criminal lawyer. If you've been charged with either driving disqualified or driving suspended, you should give us a call.